Darshak, welcome to my live show today. I'm doing this live from my Milton Keynes office. So, if we'll give you a couple of important legal update, including European pre-settled or settled status holder, the human rights application, which is also Article 8 spouse application, and also some case law, which is important decision came from the Court of Appeal and Supreme Court, and some other legal update. Let me how far I can go. So let me start with the European national or EU family member who holds settled or pre-settled status. By the way, my name is Suhail Ahmed. I'm the solicitor at SWF Solicitor. We have the office in Milton Keynes and in London. If you need any assistance, please feel free to call us, make an appointment to the number appearing on the screen. And this program is a live program, so if you have any question, you can call to the studio number and you can speak with me right now directly. But if you need to make an appointment, then you need to call to our office number at the top of the screen and the studio number at the bottom of the screen. So let me start with the European application. So the main question is, many people ask us that how, if someone has a pre-settled status or settled status, how long they can stay outside the UK, and what is the rule behind the absence to the UK and the continuous residence. This is very straightforward. If any EU national or their family member, if someone has a pre-settled status, they shouldn't stay outside the UK more than 6 months in any 12-month period. So it's not that the 12-month period is not from the January to December or the day you enter, from there to 12 months is not counted. So it start from like one arrival start now, and it should count from the next 12 months. So in any 12-month period, means if you stay outside the UK 3 months now, and your absence start from today to next 12 months, you can't stay outside the UK for more than 6 months. If you stay in any 12-month calendar period, if you stay outside the UK for 6 months, more than 6 months, what will happen? Well, first of all, if you want to apply for settled status, you want to get settled status in future, or if the Home Office want to give you automatically settled status, you must certify the Home Office that you are in the UK continuously, you are residence in the UK, continuous residence requirement, and continuous residence requirement is break if you would absence more than 6 months from the UK in any 12-month period. In that case, you will fail to satisfy the requirement of continuous resident, and accordingly you will not get your settled status. What will happen? You, for example, you have a pre-settled status, you was absent for more than 6 months, so you understand you will not get settled status. What you will get, and that is what rule withdrawal agreement position referred Annex 3, which is A3.1. It said a person limited leave to enter or remain granted under this appendix may be curtailed where the Secretary of State is satisfied that is proportionate to curtail the leave where a person ceased to meet or never meet the requirement of this appendix. So if you break the continuous residence, means if you stay outside the UK more than 6 months, then when you apply for settled status, the Secretary of State may of course refuse your settled status application and will revoke your pre-settled status, curtail your pre-settled status, and you'll be required to leave the UK because you will not have valid leave to remain. So it is very important those EU national and their family member who are in the UK not to go outside the UK more than 6 months in any calendar period. Viewers, again, this program is live, and if you have any question, feel free to ask me the question over the telephone number appear on the screen, or you can leave a comment in Facebook. Now, one other question come. Let me see. What if one has stayed outside for over a year or 2 years on pre-settled status, come back and still manage to travel in and out? At the end of the 5 years, will they be refused settled status? Yes, that's what I explained. If someone got pre-settled status or settled status, so if someone got pre-settled status and if they stay outside the UK more than 6 months, they will not get settled status, and the rules say the Home Secretary may curtail or revoke their pre-settled status. So this is the consequence of pre-settled holder. For settled holder, yes, they can stay outside the UK up to 5 years. This is what the settled. So what you need to do, you get the settled status, then go spend an extended holiday outside the UK. So this is only for pre-settled status. So this is the first issue I would like to address, that if you stay outside the UK more than 6 months in any 12-month period, your leave to remain will curtail. This was not the position before. Before, it was the Home Office position. I think when the Brexit came, the position was different. But now the current position, the immigration rules, this is what stated, that your pre-settled status will be revoked or curtailed. But if you have a settled status, you can stay more than 6 months to up to 5 years. Then the next topics I would like to address regarding case law. Viewers, if you have any question, please feel free to leave a comment on live, or you can call the studio number, which is 02037879 The next question is spouse visa application. There is a conception, there is a understanding of migrant that if you married a British citizen, you will get your spouse visa in the UK. It's not always to be the case, and this is the issue addressed in the recent case of Butt versus Secretary of State, Home Department 2025. By way of background, this appellant was a Pakistani national who arrived in the UK 2006, and later he as a visitor, and later he became an overstay, and he subsequently married a British national. In 2016, he applied for a spouse visa, and under Article 8 involving anyway the Home Office refused his leave to remain on the ground of public interest. However, the appellant, the Mr. Butt, appeal in the first tribunal, subsequently is to go to the appeal court of appeal, and this is the final decision which came from court of appeal, says that basically court said basically public interest of immigration control, Article 8 𝐒𝐻, the intervening case. So particularly that there is two cases which was relied on in the argument. Of course, basically the Mr. Butt appeal, the Home Office was right to refuse his application, because if someone want to get leave to remain under Article 8 in the UK, they must establish that they will face insurmountable obstacle, which is some obstacle. What is insurmountable obstacle? Insurmountable obstacle is an obstacle or obstacle which cannot overcome if they require to go back. Basically the obstacle which significant obstacle. But the court was agree with the Home Office, because in the same time in Article 8 case, the Home Office required to control the the public for public interest, they need to control the immigration, and accordingly the insurmountable public interest overcome the insurmountable obstacle. And then accordingly the Court of Appeal refused the application, refused the appeal, and agree with the Home Office decision to refuse his application. So what in this case was basically rely on the previous court decision, which is again 𝐶𝐞𝐠𝐚𝐥 versus Secretary of State from a 2008 case, and Alman Araf versus Secretary of State Home Department. This is the case also in the same situation, but there is a different circumstance. So in Chikamba, when they get married, he was an asylum seeker, means asylum was pending. But in this case, the Mr. Butt case, he has no leave to remain, and he was in a very odd situation when he formed a relationship. That means he has no ability to remain. In that point, he formed a relationship, and accordingly, there is a difference between the previous case, and accordingly, the Home Office refused, and the Court of Appeal as well dismissed the appeal against the refusal of an application for leave to remain. So, the conclusion is, if someone has no valid leave to remain, there is no application is pending to the Home Office, there is no asylum is pending to the Home Office, and if someone married a British citizen and applied for leave to remain, Home Office may refuse their application, which is now a precedent from the Court of Appeal. That a Court of Appeal decision is binding on the first tribunal, and if the Home Office refuse your application, there is less likely your application will be successful. So this is what the argument. So if you are in a relationship of a British citizen, if you don't have a valid leave to remain, before you make the application, private and family life or Article 8 application, you should have a consultation with a lawyer to get the right advice whether it's appropriate to make this application or you need to do something else. Otherwise, this is very important decision, because if a foreign national who has no valid leave to remain or hasn't any application is pending in the Home Office, and if you made an application as a spouse visa under Article 8, Home Office will refuse your application. If you do appeal against, you will not succeed on your appeal. So this is what the principle established by Pakistan Secretary of State Home Department, comparing with other case law. And next update, I will discuss about the Home Office. Sometime I'm dealing with one similar case. Mistakenly grant visa. Home Office sometimes do mistake. Instead of limited leave to remain, they grant indefinite leave to remain. It's a mistake, and you are thinking that, well, look, I got the ILR. Instead of I'm waiting 5 years, I got 2 years early or 5 years early ILR. And you are claiming benefit, you are claiming traveling outside the UK staying more than 6 months and thinking that I'm settled. Well, this is not to be the case. The case is if the Home Office mistakenly grant leave to remain, and if subsequently Home Office found that the Home Office grant mistakenly leave to remain or indefinite leave to remain, they can change the decision, they can correct that decision, and this is not an illegal, or this is not something what Home Office can do against the law. No, the Home Office legally can change the error, the mistake, and correct the mistake they did. And this is what happened in the case of R versus Secretary of State Home Department. What happened? This applicant, this applicant applied for asylum in the UK. However, his asylum was refused, but however, he was granted leave to remain under private and family life. And on the decision letter, the Home Office stated that you have been granted a settlement, granted a leave to remain based on your private life, and he say you have been granted settlement means indefinite leave to remain. And then his legal representative basically asked the Home Office whether this was the right decision or not. The legal representative did right things to confirm that he was granted leave to remain on. He was granted indefinite leave to remain or not. And then the Home Office found that they did an error, and accordingly they reissued the another letter confirming that you have been granted leave to remain for 2.5 years and the previous decision has been withdrawn. And then the appellant challenged the Home Office second decision to withdraw his ILR, indefinite leave to remain. Now the Home Office, anyway, it was challenged by way of judicial review, and the Home Office position was that Home Office has implied power to withdraw correct and error decision which was incidental to the statutory power under Immigration Act 1971, and accordingly they correct the decision, and this matter was proceed to upper tribunal, and upper tribunal decided, well, respondent can correct an error and any other kind of describe where the pure inadvertence, the wrong decision is communicated. So this is what, that if the Home Office wrongly or mistakenly issue indefinite leave to remain or any other leave to remain, the Home Office have right to correct the wrong decision, and you can't challenge it. Viewers, again, my name is Suhail. If you have a question, please feel free to write in a comment, or you can call to the number appear on the screen, 020-378-79200. I can speak with you live. So let me take some comment. Thank you, Victor. Thank you, lawyer. You are welcome, sir. What are the chances of a person of finance and data analytics background getting skilled worker visa for a business development executive role? Mr. Victoria, thank you for your comment. Yes, in the UK, huge demand to get data analyst or IT background skilled worker. However, what you need to do, you need to find a right employer who will sponsor you. Then if an employer who need a data analyst, if they sponsor you, will get visa. You have a good chance, but what you need to do, you need to find the right employer for you. But please remember, a lot of dozy people who giving sponsorship by taking £20,000 or £10,000, making different deal or packages. Please save yourself. Don't put you in such types of trap. I always, not even now, years after when the Home Office introduced the skilled worker and care worker visa, we warn the people live on Facebook and YouTube and our channels in different media that don't put yourself in trap by paying making a deal that someone will sponsor you and you pay them money, because if you do like that way, you will be in trouble. You'll be in trouble once you are in the UK, and many thousands people are in trouble. I'll give you some updates shortly. What is the current situation of skilled worker visa? So if you find a genuine employer, good luck for you, and you do have a strong future. Malon Gaiden, assalamu alaikum, sir. My greeting to you, sir. Thank you very much for the salam. Okay, so let me tell about the currently skilled worker visa. Okay, so the National Audit Office recommend more is done to tackle exploitation the skilled worker visa. All of us know in the majority skilled worker visa and majority care worker visa, from my experience, in my opinion, is basically people misuse and take advantage of the policy immigration rules, and they came in the UK through a deal, paying illegal money, taking illegal money, and there is no real job in the prospects. This is what all of you. Let me take one call and then I'll come back. Yes, we are. Hello, how can I help?
Hello, salam. Hello, salamu alaikum.
Wa alaikum salam. Please tell your name and ask me your question, please.
Yeah, I'm the Malang Abdul Samad. It's Abdul Samad, your client.
Oh, assalamu alaikum. How are you?
Alhamdulillah. I see you on live. I just see to call you to say
thank you so much. How is Ramadan going?
Alhamdulillah, inshallah. I'll speak to you later. I just see to
Inshallah. Thank you. Assalamu alaikum.
All right. Wa alaikum assalam.
Thank you for your call. Thank you, brother. Samad. Samad is a very good friend of me as well from Ghana, but he's living in the UK quite a long period of time. And yeah, thank you. Right, so the government, Home Office, the Migration Advisory Board, auditors, everyone know that people exploit the system and put a lot of care worker visa where they don't have their genuine job. And now majority of the care home and care employer license been cancelled, skilled worker license has been cancelled, and all the employee now in trouble. They have no job, they don't have work, they can't find another sponsor, and many of them claiming asylum. Just to give a survey report in which number of people on a skilled worker visa who later claim asylum in the UK increased from 53 in 2022 and 53,000 in the first 10th month of 2024. So people come here for work in a company, employer sponsor him, and that they enter to the UK, employer refusing to give them work. And they are not working at all. The HMRC records show they are not working. So this is the situation of many care worker and skilled worker visa, and accordingly some of them claiming asylum, and the National Audit Office gave a report and make a recommendation that in the next 6 months, work with Migration Advisory Committee, the Home Office, Skill in England, and Industrial Strategy Council, Labour Market Advisory Board to establish an agreed methodological approach to better understand the role that immigration can apply in addressing the skill shortage across different sectors of labour market. And also care worker viewers, also care worker. I don't know, Sunday someone trying to call in landline. I will not speak on the landline. This is a call in office time. But if you want to speak with me, please call to the studio number. Then I will respond. You will speak with me live. The studio number is 02037879 This is the live. You can call, speak with me now. So, and also there are more likely the labor market test, which used to be under the tier 2 work permit before, was that before you hire a foreign worker, you must satisfy that you cannot find locally any suitable candidate. And exactly this has already been introduced in care worker visa, because now probably many of you know due to the growing concern about the exploitation of overseas care worker and the failure of some provider to uphold employment. So let me take one call and then I'll come the care worker update. Hello, good evening. Good afternoon. How can I help?
Yes, thank you, lawyer, for answering my call.
Thank you, sir. Please tell me your name and ask you a question.
Yes, my name is Charles, and I sent the earlier text. There is somebody who is offering me a COS, somebody I know who is in my church, but he's offering COS for the role of business development executive, whilst my background is finance and I don't have any experience or even a certificate in that area. And I'm just wondering, what are my chances, because I'm a bit confused about the whole thing.
Okay. Mr. Charles, thank you for your call. Let me ask you a question. What visa do you have in the UK currently?
I'm on a student visa.
Okay. Have you completed your course?
Yes, I have. I have completed. So it was data science, and I've completed it, master's in data science.
Okay, all right. And currently you in PSW, post-study work permit, 2 years?
No, I haven't applied yet. I have up to May to apply.
Okay. All right. And so someone applying for the role. Okay, so let me explain you the purpose behind the skilled worker visa is that the candidate must satisfy to the Home Office that you have that appropriate level of skill for the job you have been offered. Say for example, when you apply for visa, Home Office may, in case if they think, may call for an interview, and they want to make sure that you have that level of skill or experience. If you can demonstrate that, although you come from different field, but you have that ability, you have that skill which you require for the role, the job description, of course the employer have a role, the responsibility and the experience you require for that role. You do have that. If you can't satisfy that you have that experience, or you have that knowledge, and you can perform the responsibility, and then the Home Office could bring the issue that, look, you don't have that appropriate level of skill which you require for this job, and they can refuse it.
Okay.
Yeah. So one, I'll suggest you should speak to your employer and tell them, look, this is my experience, this is my knowledge. So create a rule, give me a rule which is appropriate, in line with my skill. That will give you a better position. And Charles, you are lucky if you get a sponsorship, because in the UK currently is very competitive, and only lucky people are getting sponsorship COS. So you have to be accept it, and you should consult with him, do a meeting, explain your situation, explain what the requirement is. But one thing I also I believe you are not in this situation. Don't, because many skilled worker visa, care worker visa, basically they pay a lump sum money and they are buying a COS. If anything, you think this types of arrangement, don't do it, because I have seen every day. I'm doing consultation with people of victim of fraud and these types of things, especially people from Ghana. I have many people. I have deal with Bangladeshi people, Pakistani people. They are coming on that route by way of paying and by COS. So the reason is
they are trying to charge me for the COS as well. When I check the register, the company's name is actually on the register, but they are trying to charge me for the COS as well. And then they don't give me the role I am looking for. They want me to use business development executive, because they said the company is a medium to small scale company.
And what types of experience do you have? What types of experience you have? Your background?
I have finance, and I mainly have finance. I was a financial analyst in Ghana before I came to do MSc in data science.
Okay.
So
I think your financial data analyst. Well, look, this is two different field. I think what you need to, you talk with them, explain what rule you had and what experience you have, and explain the immigration rules. That, look, Home Office may refuse on the ground that I don't have the skill. If they do interview, I can't give the answer in relation to business development executive rules. So explain them, and then hopefully they will satisfy. Okay, Charles, thank you for your call. And good luck for you.
Thank you.
Thank you. Viewers, again, my name is Suhail. This is a live program. You can speak with me on live studio calling 020-3787-9200. I'm the solicitor at SWF Solicitor. We have office in Milton Keynes and in London. We also provide law, immigration advice, consultation, or other area of service remotely via Zoom or WhatsApp or telephone consultation. Feel free to make an appointment calling to the number appear at top of the screen 020-8090-4780, or you can text 07557226155 to make an appointment. If you want to speak with me live, you can call to the studio number. So regarding I was speaking about the care worker visa. So care worker visa, what's happened now, government change the rules, and it's some form of labor market resident test, which is basically used to be under the previous work permit regime under tier 2, that if you want to hire a foreign employee, you must satisfy that you haven't find any suitable candidate in the UK. And that what the employer need to do. Employer used to do a lot of advertisement to local job center, newspaper, Facebook, Indeed, these types of searching for a suitable candidate from the UK, and then they sponsored to the foreign worker. At the same time, they provide evidence. Look, I do a lot of advertisement locally, but I couldn't find a suitable candidate. And then the Home Office satisfy the residence labor market test, and then they issue visa. So these types of system we're introducing in the care worker visa, and this is because the Home Office and the migration advisor were there aware about that many thousands of thousands of care workers came in the UK, and now their employer license has been cancelled, and now they are in a limbo. And now these people who are already in the UK, they should have priority to get a job, and accordingly they are making the rules that now if you want to sponsor a care worker from outside the UK, first you need to satisfy that you takes time to recruit a local care worker, those who are already in the UK, say for example under other employer whose license has been cancelled. So this is the update for care worker visa, which is good news, because the people who are in the UK, they are in trouble. Their employer license has been cancelled, someone waiting for 60 days later, someone has already received 60 days later. So now the employer should give them priority to recruit. The other thing is, also the government is raising minimum salary threshold for skilled worker for care worker visa from 23,200 to 25,000 per year. So this is one of the updates. So well, the thing is, people have exploited the skilled worker visa, care worker visa. Some people become a millionaire, some people become lost their everything. They sell their property asset, borrow money, take loan from the bank, and they come to the UK, and now they don't have job, they don't have visa, they need to seek an asylum where the asylum has been refused. So this is the update for everything, viewers. This I will end my live show. Thank you all of you who watch this live program and subscribe my channel. My name is Suhail. If you have any question or if you need any assistance, please feel free to contact me to the number at the top of the screen to make an appointment, 020-809-04780, or you can WhatsApp 0755-722-6155 to make an appointment at SWF Solicitor. We have various areas of practice, immigration, family law, commercial property, and other area of law as well. We are happy to book an appointment online if you live anywhere in the UK. So this is for all today. Thank you very much.